Good morning, everyone. Happy Monday morning. I am Carol Williams, and we are back for another edition of Beyond the Soundbite, where we talk about all things U.S. immigration. And I am the founder of Williams Immigration, which is a boutique immigration law firm where we help businesses and families navigate our very, very complicated U.S. immigration system. So, the first thing I want to talk to you about this morning are the employment based green cards for the remainder of this current fiscal year 2024. So, we have seen a lot of things in the media so far about the green cards, the employment based green cards. So, as of right now, the only applications that USCIS is currently processing for green cards are those that are in the EB2 category. So EB1, EB3, all of them, they have been used up. So what does that mean? That means that for the remainder of this month, so for the remainder of September, the U.S. Immigration Service is not allowed to approve employment-based green cards that are in that EB1 and EB3 and EB5 category. That is because a certain number of employment-based green cards are allowed to be issued every year. The U.S. immigration system, has reached their limit for this fiscal year. It is important to know that the fiscal year ends at the end of September. The government fiscal year will restart October 1. So the government doesn't work on a calendar year, they work on a fiscal year that goes from October 1 to September 30th. So we're not in a situation where we have to wait until December, several months. We're waiting until the end of this month, the end of September. That said, the Immigration Service has told us, the Department of State has told us that they think we may see the unavailability of the EB2 category as well before September ends. So while this may not be sort of great news on the surface, because obviously the Immigration Service is not going to approve, EB1 and EB3 green cards in the month of September, it is actually a good thing in that the Immigration Service is using all of the visa numbers. So we have had in the past where they have not used all of the visa numbers, they've gone unused. So that meant that people that were eligible for green cards were not approved for their green card. So we may see the unavailability also of EB2 in the coming week or weeks. Certainly, if that happens, I will let you know. Now, the difference with this particular fiscal year so far and prior fiscal years is usually when a visa category is unavailable, meaning the Immigration Service cannot approve or deny or process any applications. They usually say that those applications are unavailable, those numbers are unavailable, and because they are unavailable, we cannot file applications this month. Well, they've said something a little different this year. And this year they have said the numbers are unavailable, they're completely used. We cannot process anything else except for EB2 category, but you can still file your application if your priority date is current. That's huge. So there's a lot that goes into sort of figuring out the strategy of if your priority is current, but if the number is actually unavailable, do we file? Do we not file? What do we do? So, we're kind of working through that in the firm right now with each individual case, because as we know, no two cases are the same. So that is a huge announcement. So again, EB1, EB3, and EB5 are all unavailable, meaning the Immigration Service is not going to be processing any of those applications for the remainder of September. And EB2 is currently available according to the visa bulletin. And so we'll have to see if that category as well becomes unavailable sometime through September. But as of right now, immigration has said, even though the numbers are unavailable, if your priority date is, still current, based on what the current visa bulletin says, then we can file them, but just know immigration is not going to actually process them. So what I'm telling my clients is, we can get your application together, we can get it filed, but it's going to sit on a shelf, right? And that's okay. That means that immigration at least has it. So one step further in the process, y'all. So that's what we have for the employment-based. And remember, that is only for employment-based. There's a completely separate visa bulletin for family-based applications, but this is just right now for employment-based applications. The second thing I wanted to talk about this morning is we will have access to a new overseas USCIS field office. So at the end of last month, USCIS announced that they were opening a new overseas field office in Quito, Ecuador. Now, to be clear, y'all, this is not an office where we can just go up to the door, knock, and go in and file our applications and ask them to do things for us. So it is not that kind of office. It is an overseas office. The types of matters that they handle are very specific and very niche. And they've said that this office, one of their duties will be to help settle refugees that are coming from within the Americas. So Central America, South America. So that's great news. That means, that frees up more resources for USCIS to help those folks that are coming up from the Americas. So shortly, I think they said maybe on September 10th-ish, somewhere around there. So sometime this week, that office should be up and running, and it will be co-located in the U.S. Embassy in Ecuador. So that's great news. The next thing I want to talk to y'all about is the parole in place, keeping families together. So last time we spoke about this, the USCIS started accepting applications on August 19th, I believe it was. Shortly after that, there's a lawsuit filed in federal court down in Texas. That judge put a temporary hold on USCIS being able to process these cases. Even though there is a hold on USCIS processing, USCIS is still accepting cases. So again, you can file, but it will sit on a shelf because USCIS is not able to process them because it now sits in litigation. So that hold, supposed to be a temporary hold, has now been extended out until September 23rd. So in the meantime, again, USCIS can still accept cases. They can still, get them, open them up, receipt them in, but then they're going to go sit on a shelf. So just keep that in mind. So I will keep you updated on that. I think that that litigation is going to be probably front and center for a little bit, at least until the 23rd, when we figure out if it's, what's happening on the 23rd. Will we be able to file and have USCIS adjudicate, or will it still be this kind of limbo land? So we'll see. I will keep you updated on that. And for those of you that may not remember, the Keeping the Families Together parole in place is for individuals that entered the U.S. without status. They have been residing in the U.S. for the last 10 years, and they are currently married to a U.S. citizen. It gives them a path to applying for a green card without having to leave the U.S. Prior to this new policy, folks had to, under those circumstances, people would have to leave the U.S. And process the final part of their green card overseas at a U.S. consulate. So we'll see if we get that back. We'll see what federal court in Texas does. I will keep you updated. The next thing I want to talk about is we've got some new visa categories, which is kind of cool. So recently, Department of State announced 2 new visa categories, and they are a C as in cat 4. So a C4 it's a transit visa that allows people to transit through the U.S. if they are going to join a lightering vessel. So honestly, y'all, for most of you listening, this is not applicable. But For those folks that work in open seas, who work on the large vessels, this is amazing. The second new visa classification is a D as in David 3, so a D3. This permits crew members to actually perform the lightering duties on board the ships. So you can also apply for a C4D3 combo visa that will be valid up to 180 days. So if you are in that sort of marine maritime world, this is absolutely huge news for you. So that's great. If you have any questions, any further questions about that, you're welcome to contact my office, and we're happy to chat with you about that. And the last thing I want to do is talk for a minute about national interest waiver. So I've been giving y'all tips about national interest waiver for a while now. National interest waiver, for those of you who may not know, it is a green card category. In order to get approved, you have to show that your proposed endeavor, your career path, what you want to do, has both substantial merit and national importance to the US. You have to show that you're well positioned to advance your endeavor if the green card is issued, advance it in the US, and on balance, that it would be beneficial for the US to waive the normal requirements. Waiving the normal requirements, those normal requirements are essentially filing a perm application and testing the US job market to make sure that no US citizen is qualified to do the same thing. So those are the requirements. National interest waiver is a great category. I just told you what the requirements are, so it's very flexible, and I really like it because it's very flexible. It allows you to really explain to the Immigration Service what you're going to be doing, why you're the best person to do it, and why they should allow you to do it. Like how are you going to be impacting the country? So it's very, very flexible in that respect. And it's very flexible in terms of the types of documentation that you can submit. So you can dig really deep into your specific industry and do that. Now, I have seen a lot recently about how some people are saying, the national interest waiver just solves all the problems. It doesn't solve all the problems. It does not solve all of the backlog problems. It solves some of them, but it does not solve all the backlog problems. So you can use premium processing. You can request premium processing, which is an expedited processing time from USCIS. Using premium processing and getting your national interest waiver approved is great. If you need to extend your H-1B, which is your non-immigrant status, past your 6 years, national interest waiver is a great option for that if you qualify. All of these are if you qualify, if you have the documents that we need to present to the Immigration Service. National interest waiver is also great because you skip the entire perm process. So you skip the test of the US market. Right now, that process is taking roughly 2 years. So who wouldn't want to cut off 2 years off of their green card application? So it's great for that, right? Now, just because you're in a STEM field does not mean that USCIS is going to automatically approve your national interest waiver application. It doesn't matter what your industry is, we still need to provide the Immigration Service with documentation. I can say as the lawyer that you're the best thing since sliced bread and you're going to have this amazing impact on the US system, whatever in your industry. But I need documentation because frankly, immigration's not going to believe me. They are not going to believe me, right? But they will believe independent documentation from third party. They will absolutely look at that. And the other great thing about national interest waiver is that you can self-petition. So you don't actually need a company to stand behind you and make that application for you. However, the combination of self-petitioning and requesting expedited or premium processing also does not mean an automatic approval. So national interest waiver can be great depending on your individual circumstances. And it can help you get beyond the 6 years of H-1B, but it is not a cure-all for the backlogs that are currently at USCIS. It can certainly help in some cases, but national interest waiver, it's a lot of work, and requires a lot of documentation. So my job is to really look at your entire immigration situation, your entire immigration past, your immigration history, and your goals moving forward. What do you want to do ultimately? And help you. And then we decide if, in fact, national interest waiver is the best way to go for you. So I do that for my clients. I actually really kind of love that whole strategy piece of the puzzle and implementing it on national interest waivers. I think it's fun. My clients are amazing. They're doing some really incredible things. But we need to be able to explain what people are doing to the Immigration Service and using documentation as the backbone of that explanation. So if you have a national interest waiver question, if you have a question about the new visa categories, the C4 and the D3, you have a question about the family, keeping families together, parole and pleas program, or the visa bulletin, feel free to reach out to our office. We're here to help. It's what we do all day, every day. We do it because we love it, and we do it because it's interesting, and we do it because we want to help people. So that said, have a wonderful rest of your Monday and a great rest of your week, and we will be back following Monday with another episode of Beyond the Soundbite.